be the human mic stand. So that's what we only have one microphone, so that's what's happening here. Just wanted to explain.
Should we do introductions first, and then we'll jump
Yeah,
in?
that
So I'm Pamela Chestek. I am an attorney from the United States.
I'm Andrew Katz. I'm a lawyer from the UK, and I advise a lot of free and open source software companies.
Hi, my name is Michaela MacDonald, and I teach at University in London, Queen Mary.
And what jurisdictions do you?
Oh yes, and I'll be looking at civil law traditions in the EU.
So I proposed this talk because it's kind of this. Always to me it's the elephant in the room is it a license or a contract? Are these open source licenses license or contracts? And it finally occurred to me that the answer is probably different under different legal systems. And so I thought, well, why don't we figure out the answer to this question? And I'm happy to say that in putting together this panel and working with these panelists, it turns out the answer is really different in different jurisdictions. So I'm glad we did this little exercise. So I'm going to start with it. I'm going to start from a U.S. perspective, and then we'll do the U.K. perspective, and then we'll do, the English
perspective.
And then we'll do the EU perspective. So from the U.S. perspective, there's this, a license is not, it's not a thing. It's a grant of permission to use a copyrighted material. And it can either be express, written, or oral, or it can be implied in conduct. All it is, a license in the United States is simply a defense to an infringement. So if you are accused of infringement, you can say, I have a license, and as long as your behavior is within the scope of whatever that expression is, whether it be written or whether it be oral or whether it be by conduct, as long as you can show your conduct fell within that, then you have a license defense and you're not an infringer. So a contract is a different concept altogether, and a contract is an agreement between two people. It requires an offer and acceptance and mutual consideration, meaning that both parties gain a benefit from this relationship. Now, it has been established in the U.S., there's a little bit of jurisprudence in the U.S., it has been established that for open source licenses, this consideration on the part of the offeror, on the part of the licensor of the software, the benefits include generating market share for their programs, increasing their national or international reputation, or improving a product. So from the licensor perspective in the U.S., that is consideration, that is the benefit for you granting this license. So what we have in the United States is so this to me would be, and I'm using the word bare license because it is a term that's used sometimes. It's not really a term used in the United States or understood in the United States, but I would say that a bare license is simply an agreement for a license that has nothing else. But you can, typically a license is going to have a lot of different things going on. So obviously, if you've gathered my analogy here, the yellow pepper is the copyright license. But often the contract will have many other components to it. An agreement will have many other components. And in the U.S., what this turns on, the question then becomes, when you have this written document that has a lot of obligations in it, which ones of those are conditions of the license, meaning if you have not met those conditions, you don't have the copyright license, or which of them are other requirements within the agreement, but not a condition on the license. So for example, an example of a condition is the courts will look at words, and they'll look at words, and here you can see, so this is from the GPL, you may convey a work, provided that you also meet all of these conditions. Well, that's pretty clearly stated what it is that's going to be the conditions for the copyright license. An example of what might be a condition on a copyright license would be you may not create a derivative work, contrasted with a covenant that is not part, which is maybe in the same agreement, but not a condition on the license would be you're not allowed to disparage the licensor. So that has nothing to do, so that may have nothing to do with the copyright grant. And so so again, back to if I fail to meet the conditions of my license, I'm a copyright infringer. But if I simply fail to meet a covenant, if I disparage that website owner, that may not affect the copyright license and is apart from the copyright license in this comprehensive document that may be about more than just a copyright license. So in looking specifically at some licenses, I looked for the shortest license I could find, the one that I thought might be most what I could characterize as a bare license that really is just about copyright and nothing else. And I came up with, and the shortest one I could find is the fair license, which is this, which just says clearly permission to use the work, and then the disclaimer, the works are without warranty. And the next license I thought about was the BSD 3 clause, which I'm not going to, which you can't read from that slide. The slides are all on the website, by the way. And so under U.S. law, when I look at it, I think, okay, this concept of a bare license, is the fair license a bare license? Is it just about a copyright license and nothing else? I have question marks. Maybe that extra warranty language, that extra disclaimer language, maybe that isn't part of the copyright license. But this is the only one that I would say might fit in that category, sort of bare license and not a contract. The BSD, the aspect of the BSD that I looked at and said, okay, well, this is back to my concept of conditions or covenants. The BSD was, let me find the language. Oh, the BSD, huh? Yeah, you won't be able to read it, but yes. There we go. Actually, thank you, because it was easier than finding my piece of paper. So number 3, neither the name of the copyright holder nor the name of its contributors may be used to endorse or promote products derived from this software. That really has nothing to do with the copyright grant. So I looked at that and thought that's probably a contractual condition, not a covenant. I'm sorry, a condition. It's not a condition of the license grant. That is a contractual covenant, and this then is a contract between two parties. So under U.S. law, I say fair license may be on the fair license, but basically they're all contracts. I think we're going to have to save questions to the end because we have 3 people at very short time. Okay.
Brilliant. Thank you very much. I'm going to come over here so I can press the button. So thanks, Pam.
Both are giving
Is that
sequential
okay?
presentations. Let's do this.
Oh, okay.
I like being a human mic stand.
Okay, let's hope that works. Yeah, so I'm talking specifically about English law, which covers the law of England and Wales, and I'm assured by one of my Northern Irish colleagues that the law is going to be interpreted the same in Northern Ireland as it is in England and Wales, not Scotland. So we're not covering Scotland, which is much more of a civil law jurisdiction. Just when you look at the different sorts of contracts that we have, a proprietary software license is typically a bilateral contract. So that means that there are rights and obligations on both sides. It means that it's the sort of complex contract that Pam was talking about earlier, and I don't really propose to analyse that much further. But free and open source software contracts tend to fall into a different category. And if we look at what a bare license is from an English law perspective, it's basically a promise not to enforce rights that you may have, such as copyright. But the problem is that if it's not enshrined in a contract that keeps it active, it means that the person making the promise is effectively able to withdraw it at any time, which makes it fairly useless for anyone relying on it. And the courts understood that this was a fairly unfair scenario. So they came up with the concept of estoppel, that means that if somebody grants a license and then you rely on that license, then they're no longer allowed to revoke it. It's slightly more complicated than that, but that's basically the situation. Now, there is a halfway house here. There is this concept of a unilateral contract. So the sort of contract I mentioned before, bilateral contract is one where there are mutual promises given on both sides. A unilateral contract is a contract where a promise is only given on one side, but the other party acts in such a way as to make it binding. And the classic example is this case with the wonderful name of Carlyle and the Carbolic Smoke Ball Company. And basically the promise was that they advertised that they would pay £100 to anyone who used their product and if they contracted the flu later. And this was very, very widely advertised. So it was a Victorian case. That won't surprise anyone particularly. So the Carbolic Smoke Ball Company advertised that anyone who did get flu could get in touch with them and they would be paid this £100. And this was backed up by, they deposited a sum of money in a bank, and they're obviously very, very serious about this. Now, I haven't researched what the carbolic smoke ball is because I think I'd probably be disappointed with the reality. I always have in mind that it's like some sort of toxic smoke grenade, which is full of all sorts of noxious agents, possibly radium, this sort of thing. Mrs. Carlyle was using this thing on a daily basis. And on the upside, these noxious agents failed to kill her. On the downside, the noxious agents failed to kill the influenza virus, and she caught influenza. And probably even more unfortunately, they also failed to kill her husband, who happened to be a trial lawyer. So once she recovered from her influenza, she started a court case against the carbolic smoke ball company, and she won her £100, which was a lot of money in those days. This was before the Brexit vote. So the court case involved quite a lot of argument around offer and acceptance and communication and acceptance and offer and so on and so on and so forth. But the upshot of it was that the court wanted to construct a mechanism by which Mrs. Carlyle had a means of effectively suing the smoke ball company to get the £100 out of them. And this is basically why they invented this idea of the unilateral contract. So free software license is different. So if Mrs. Carlyle had been using software under the GPL, there are no circumstances in which she actually needs an enforceable right against the copyright owner. The only thing that could happen is that if she happens to be using the software within the scope of the GPL and the copyright owner tries to sue her for doing that, for copyright infringement, then she can put up a shield and say, no, I'm complying with these conditions, go away, you can't do this. So there aren't any circumstances in which she's going to initiate a claim. Now, it's also worth bearing in mind that if going back to the smoke ball example, if Mrs. Carlyle used her smoke ball incorrectly, there's no way that the smoke ball company would have any claim against her. For them, it would just be a shield against if she tried to claim the £100. They could say, no, you're not allowed the £100 because you didn't use the smoke ball every day as directed. So there's no need for a contract. There's no need for a contract in the GPL example. So the fundamental question is it actually necessary to imply a contract? And the answer to that is no. And this is where I rely on an English case called Robin Ray and Classic FM, and I won't go into the facts in any depth there. But the court came to the conclusion that if it's going to be implying terms into contracts, it can only imply those terms to the extent that they're necessary, and no more. So my argument is that surely that applies to contracts themselves. If you can obtain the full legal effect required without implying a contract at all, if the concept of bare license is sufficient to enable you to do that, then why do you need to imply a contract at all? So really looking at the grid again, I mean, I sort of now I'm actually prepared to be persuaded more slightly by Pam's argument on the BSD. But I still think now I think my argument still holds that each of those licenses can be interpreted in such a way that's entirely consistent with the concept of a bare license. And there's no necessity to imply a contract there. There are some question marks around GPL. I think there should only be one question mark. I got a bit overexcited and put 3 in. And this is for the really sort of non-legal idea that there is obviously wording inside GPL that actually says there's no need to accept this license, etc. It talks about acceptance. But it's almost the fact that it's objecting so much that acceptance isn't required that the court is bound to be awkward and say, well, actually, that means it probably is. But you know, that's just reference to the idiocy of judges, really. So that's it for English law. Now on to other jurisdictions. Do you want to pin that on, or shall I hold it?
No, it's fine. No, she just needs her notes, but we have the slides on this one.
Further up.
So that microphone is very sensitive.
Is that better? Yeah? Okay. Right. So just to go, or sort of focusing on the main differences between US English and the civil law tradition. I'll be talking about civil law tradition in general, looking at the EU. Obviously, there are a multitude of different legal systems, and there is no scope to go into all of them in detail, so I'm just focusing on some general legal principles. And basically, the main difference is that software licenses, proprietary or FOSS, would be interpreted as contracts. There is no such an independent concept of bare license or of a specific legal category that would apply to open source licenses. The license itself, therefore, needs to meet all the relevant contractual legal requirements. We would be looking at offer and acceptance. The main difference between common and civil law principles is that in civil law, the focus is on the parties' obligations rather than on the parties' promises, like it is in common law. That is why you would have the option of both unilateral and bilateral contracts, where your unilateral will would create obligations that would be enforceable. So again, the idea of donation or gift creating an enforceable contract. But in this specific context, we would look at whether all the requirements are there. The license, again, would be seen as an agreement where the licensor grants the licensee permission to perform certain acts that goes beyond the copyright. And when sort of looking at the different licenses, whether there is a concept of bare license, or whether it is a contract, again, the answer is it is a contract. There are a number of cases, especially in Germany, that sort of tested the validity and enforceability of clauses under the GPL, and the court has confirmed in both cases. One was the, for example, the Welte versus Sitecom Deutschland GmbH, and the other one also involved Welte and Dealing Germany, where the court has confirmed that these clauses are enforceable, enforceable under copyright and are valid. In terms of, again, the... Oh, there are some slides missing?
I didn't.
I thought there were more of the grids, you know, comparing
We do.
the...
We'll do those next.
Oh, right.
Yeah.
Oh, okay.
We can go there. But yeah, we can go there if you're ready to talk about them. So we also, there are some additional slides that we won't have time to go through individually.
Oh,
Oh, sorry. Yeah. So there are some individual slides. The disclaimer, you know, we could be wrong because this is just individual opinions of individual lawyers, but just some very quick slides, and just jump in if you want to say something. So just we have this sort of taxonomy of, you know, bare license, unilateral contract, bilateral contract, some basic facts about each of those under the legal system. So you can see under the EU, there is no such thing as a bare license. Are these revocable or not? Is one of the slides. As I said, these are on the website, so you're welcome to pull these slides down. Which concept in particular did you want to?
I just want to say that obviously the difference, yes, then the difference in the interpretation would lead to different legal effects. So as it is a contract, there would have to be certain elements present. You would be looking at whether there was an offer, whether there was an acceptance. Again, civil law does not hang on to the concept of consideration, so that is not relevant, but requires other formalities, whether the the contract was agreed for legal purpose, whether the party was capable of entering into a contract, and so forth. And you would be looking at whether, for example, in the licensing chain, all these formalities have been met, whether it is possible sometimes to identify all the relevant parties in the licensing chain, and therefore there has been a valid contract concluded. So that would be the difference between looking at the license agreement from the perspective of a bare license or a contract, from the perspective of common law or civil law, as to the legal effects that the contract would have.
Yeah, so just some summary slides here. So third-party beneficiary is, can a user enforce this contract, particularly for the GPL? So the person who has not received the source code, who should have received the source code, is that person able to make a claim that they're entitled to it? Does this contract allow that? That's one concept that's very interesting. Specific performance means, can you get the licensee who has not performed, can you oblige them to perform, or instead, can you simply force them to pay damages for their noncompliance? What remedy is available? Specific performance being, as it sounds, performance versus just a payment of damages. And then legal costs, whether or not which party may be, whether a party may be entitled to recover their legal costs, also a contract concept. And excluding liability, whether it's legally feasible and possible. Sometimes one is not allowed to exclude liability. And so so again, sorry that we don't have time to go through all of these concepts, but they are there for you to look at. And we have, I think, 4 minutes for questions. First hand, yeah.
Give us a little bit of a walkthrough on why the third clause of the BSD would be with a covenant, not a condition?
Yeah, so so the question was, can I give a walkthrough on why I believe that the third paragraph of the BSD is a covenant and not a condition? So that's a narrow reading. So part of it is sort of the structure of the license. It doesn't use the sort of magic language. The second is that there is some law in the United States that says that conditions have to apply specifically to the copyright grant. So not to use the name in advertising has nothing to do with copyright whatsoever. So some courts may interpret that and say, therefore, it's a condition, it's therefore a covenant, not a condition. Second question, yep.
The precise difference between the BSD 3 clause and the BSD 2 clause license is that.
Yes,
particular-
that's
So
why I picked the
you think-
three.
you think the BSD 2 clause license could therefore be a bare license in US law?
So again, to the extent that bear license, so again, this is, the question is, so the difference between the BSD 2 clause and the 3 clause was exactly that paragraph that I cite to, which is why I used the 3 clause as an example. And the question is the BSD 2 clause a bear license? Again, back to, that's really not a concept under U.S. law that, are all of those conditions of the copyright grant possibly? You also have the disclaimer of warranty, which may affect it too. I think most courts would just look at it and say it's a contract, and the fair license was the only one that I could kind of look at and say there's really nothing there but discussion of the copyright grant. Another question, Jelaine? Yeah, so So let me clear. So the question is, isn't it both? And the answer is yes. It's always both. So to the extent that a contract contains a copyright license, then it is both. Now the difference is if I've breached my license. So remember, it's a defense. So that if I don't meet the conditions for the defense to say I'm not an infringer, I am an infringer, and therefore the licensor may be entitled to copyright damages. If the breach of the agreement is unrelated to the copyright license, I may not be in breach of the license. I may still have the copyright defense, but my offense is something else related to the contract. Say, for example, I disparaged you. Then I'm entitled to my contract remedy for disparagement. So you can recover both types of remedies under the agreement. You just can't have duplicative recovery. Let me see. I'm going to do this question here. Yes.
So this is a question about the English.
Yes.
The GPL in particular states quite clearly that its purpose is to secure certain rights for everybody, particularly downstream of the licensee. Now, obviously, it's also got this language in it which tries to make it very much clearly just a bare license.
Yeah.
Is it possible that you might be able to persuade the court to read the GPL purposively and say that the source code provisions were intended to be enforceable by a downstream?
Right. Okay, to summarise the question, so as far as the GPL is concerned, then its stated intention is to secure rights for users of the software. The reality is that's contained in the preamble, so I think we'd agree that's some non-contractual part. So the question is, would the courts interpret that purposively to try to create a situation where licensees are able to enforce? So any recipient of the software, for example, could claim against somebody upstream who wasn't providing the source code, for example, to do that. My personal view is that's difficult to do. I mean, I think it's an interesting argument. Part of the problem is that there's a number of different ways of complying. In order to get specific performance, the court is going to have to choose, what mode of compliance is the appropriate one. I don't think any court is ever going to want to do that. So courts are very, very uncomfortable about applying specific performance anyway. And if you're going to look at a purposive approach, which is something that is fairly alien to English courts anyway, it's much more of a civil law concept, then you would bring in the whole of the concept of the Free Software Foundation's view that it's only the copyright holders that should be able to enforce rather than the recipients of the software. I think it'd be a slightly sort of scary concept, I think, if the recipients were able to enforce, but there's a possibility that, under German law, as I understand it, there's a possibility that might happen in Germany, but it's less likely to happen in England, I think.
I think Jim had his hand up, or do you want to cede your question?
No, I want to hear Jim's question.
Comment on any implications that don't mind with respect to whether someone who's relying, who has failed to comport with conditions would therefore be subject to revocation because they could not claim that they were relying on the license.
Who's going to take that one?
Yeah, I'm trying to make sure I understand it. So you're saying someone hasn't complied with the license?
Someone fails to comply.
Yeah,
Someone fails to comply. Can I now claim?
that the license is revoked. That's a really fascinating question that we actually discussed at dinner last night. and I will commend you to, what was the case I was just reading? Oh, Artifact Software, which actually does have a discussion on the automatic, this is sort of thrust is the automatic termination versus, I don't know if that's, but I would, so if we're just we're just talking about the conditions to the copyright license. We're not talking about the contract. We're just talking about the license. I'm just going to stick to the license. So I do think that if you are meeting the conditions, so to me, I look at it and say, am I meeting the conditions of the license? Do I have the defense? Now, it doesn't say, yesterday was I meeting them. It is, at the time I am accused, do I have a defense? And am I in compliance with those conditions? And that to me seems like yes or no. So I can come into I could have been out of compliance, but I wasn't accused of infringement at that point in time, so it was a moot point. It only matters when I'm accused of infringement at that point in time, am I in compliance or not? I don't know if that, has that answered your question? I put a fine point on it, or you want to?
If someone has failed to comport in terms of the requirement, the attribution of rights for the BSD license, can the licensor turn around and say, you're infringing and
The license has terminated.
and you cannot come back?
So the question is, can you say that the license is revoked due to this noncompliance? That's a question of state law, which will vary from state law, from state to state. What are the opportunities? What are the situations under which one can terminate an agreement? So, yeah.